Good evening, Texas AFT members. My name is Zeph Capo. I'm the president of the Texas AFT, and we welcome you to this evening's Know Your Rights session. I want to say hello to everyone out there who's watching, in addition to our members. Thank you to fellow educators that could be tuning in, as well as our friends of public education. I'd like to start off by introducing the members of our panel this evening. Joining me tonight will be, first of all, Martha Owen, our General Counsel for the Texas AFT. As well, Patty Quincy, Legislative Counsel for the Texas AFT, and Jamie Womack Williams, the Director of Professional Development for the Linda Bridges Institute with the Texas AFT. I'd like to go over our agenda for today. If we could start that PowerPoint. One second while we pull that up. While we're pulling that up, I'll start walking through the agenda. The first part of today's Know Your Rights training, we will talk about your right to organize and your right to build collective power. We will touch base on what we spoke about last month, which is the Family Medical Leave Act and ADA accommodations that you may potentially utilize during this time with COVID. We'll also talk about whistleblower protections for public and school employees who are going through the COVID crisis on our campuses. In addition, statutory rights that you have as public educators during normal times. Once we've gone through these periods, we'll have an opportunity to stop and take some question and answers before we then break into part two. In part two of our session tonight, we're going to go deeper into detail on your First Amendment rights as public education employees. We will talk about speech as a public employee and how it relates to your workplace, how to engage in social media and other digital platforms as a public education employee and in the context of your First Amendment rights. There's been a lot of questions about striking in Texas, and we will certainly talk about that and other work actions as they impact you as public education employees. And again, we will have an opportunity then to take questions and answers from the group. So what I'd like to start off with, next page in the slide, please, is your right to join a union. As a public employee, you have the right to join or not join a labor organization. You have the right to have your to paycheck deduction. One of the fundamental rights to start your membership with the union. That's been a controversial issue over the last several years with the legislature as the forces that work against you have tried to curtail that. We are working hard on that, and we've worked hard to make sure that your rights are not curtailed, but we also have put systems in place because we want to be prepared. I fully recommend each of you join by bank draft. It's time that we own our power. It's time that we not allow others to have leverage over us. Having a direct relationship with your organization through bank draft and our eDo system is a way to take that power away from those who would rather control you in a way that is not in your best interest. I want to talk a little bit as well too, because throughout a lot of this process, we've seen many of our colleagues out there who either aren't familiar with the fact that we do have unions in Texas or aren't familiar with what those processes are, to really give some context around that, because what we can't do is we can't allow those who say no or those naysayers that say you shouldn't join an organization to stand in our way. And I want to put some context around that. Margaret Haley is considered the matriarch of our union. She was a teacher in Chicago public schools back in the days when teachers, particularly female teachers, were paid less than men, when they had different rights, when they had no rights, when they were required to live in the homes of their students, when they were required to be single and not married. She joined the union in 1898. In 1916, she helped form the American Federation of Teachers. In 1937, the CTU was formed, the Chicago Teachers Union, And it was 1967 before the Chicago Teachers Union won their first contract, actually got to collectively bargain. I want you to take a look at that time frame. I want you to take a look at the work that it took to get them where they are. We started our union in Texas in the 1970s. We are leaps and bounds ahead of where they were when they were in their process. The only thing that we have to fear is fear itself. The only thing that we have to do is not let the naysayers out there keep us from building power, keep us from building our voice together as educators to advocate for the best interest of our members and the best interest of our students. That's why this is important, because you never know when a COVID crisis is going to come. You never know when you're going to face the things that we're expected to face this August as compared to last August, because it's not the same as it was before. This year is not going to look like it did last year or many of the years before whenever you return to school. And fortunately, we have long-standing unions that have been in place. If you talk about and look at the collective actions, one of our rights under free speech and free speech and the First Amendment is our right to contest actions that we don't believe in, our right to be engaged in public policy. And where we have strong locals, we've seen the most progress across the state of Texas. Look at some of the actions that we've been engaged in around COVID. Unionized members, non-unionized members, others coming together to build their voice by sending letters, by engaging in car caravans, by going through the protest process, by speaking to the board. When we bring our voice together, when we have that larger voice, we're able to make more happen. We're able to build the power that we need to see change. And as Frederick Douglass reminds us, if you remember his words, probably one of his most famous quotes, power concedes nothing without demand. It never has, and it never will. And until we develop a strong enough voice to be able to build the power around to put our demands in action, we will not be able to get the concessions that we're looking for. And it's not like we're asking for anything that we don't deserve. Every single one of our members out there deserve a safe workplace. Every single one of our members deserve the ability to be able to go in every day and not be concerned that they're going to get sick or they're going to bring a virus home to their family. Every one of our members deserve to go to work each and every day and not worry about if any of the students that they're in charge of are going to get sick because the processes weren't followed, because there wasn't enough protective equipment in place. These are the things we're fighting for. This is the reason that we're here today. And I want to thank you for participating with us today in this Know Your Rights session. I want to talk about some of the collective action works. There's no coincidence that where we've had the strongest, most engaged unions, we've also had the best developed reopening plans that have safety at the core of those plans. Where we have those strong unions, we have members that are educated on their rights and educated on the processes. They're actually sitting at the table to help develop these plans. They're part of the decision-making process. And when our members are able to be part of the decision-making process, then we end up with plans that could put staff and students at the core of the mission. We're very proud of our locals that have been engaging in this process and then standing up where they have to try to make things safer for our members. And we're going to continue to do that as a union on the local level and on the statewide level. So at this time, I'd like to turn the stage over to our General Counsel, Martha Owens, so that she may give us a reminder of what we talked about last month with the family medical leave, with the ADA accommodations and others. Martha.
Hi, everybody. Thanks for attending this webinar. I'm going to make a shift from what Zeph talked about in terms of the agenda. We had so many things to cover today. The ADA accommodations piece it was really too much to talk about today. And we've done a webinar on that where that's available from the Texas AFT website. So I thought we would talk a little bit about a couple of different laws, and that'll allow us to time to also talk about the Whistleblower Act. So I wanted to talk first about two provisions in the federal law that Congress passed in March, the Families First Corona Response Act, or FFCRA. There are a number of aspects about it, but we're getting a lot of questions on these two particular provisions. So let me touch on those. The first is an expansion of the Family Medical Leave Act. And and I'll talk about the expansion piece in just a second, but just to kind of review, I know many of you are familiar with the basic provisions of the FMLA, but just in case for those on the webinar who are not, the FMLA provides 12 weeks of unpaid leave if an employee needs to take time off to care for herself or her family. And this would include reasons related to COVID-19. You have to have worked for the district for a certain number of hours, 1,250 hours over the preceding 12-month period in order to qualify. But assuming that you qualify, if you have a serious medical condition that renders you unable to perform the essential functions of your job, or to care for a family member who has a serious medical condition, that leave is available. So I mention this because plain old FMLA may be an option for you if you need to take time off. For example, if for those of you who may have serious underlying medical conditions, and if you've asked for an accommodation from your district and you have not, for one reason or another, received the accommodation that you have requested, for example, to teach remotely, and you try to work that out with the district, but that is not going to happen for one reason or another. Taking FMLA for that serious medical condition may be an option for you. Now, keep in mind, it's unpaid. The district, if you have leave, paid leave in your various leave banks, the district can make you take that paid leave first, and you may want to take the paid leave because obviously it's paid. But the entitlement that you get under the federal law is unpaid. So obviously that's a big disadvantage. But there are two very distinct advantages to FMLA that may help you out if you are facing a situation where you are thinking about leaving your job because of the challenges that we're facing because of COVID-19. Think about taking FMLA. It may give you enough leave, off from the particular situation we're facing with the pandemic, that we get past that critical time, hopefully, and before you have to come back from work. And during the time that you are off, you are entitled to continue your health insurance on the same basis that you have it now with the district. And when you're ready to return after your leave is up, then the district has the obligation under federal law to place you in a substantially equivalent position to the position you had when you left. So those are, FMLA, just the plain old FMLA is definitely an option for people to consider. Okay. Then let's talk about the expanded FMLA. That is FMLA this is what they did under the Family First Coronavirus Response Act. And that allows you it expands the reason so that you can take the FMLA if you're child's school or child care, your daycare or child care provider is not available due to COVID-19 related reasons. For example, your daycare has closed because of the pandemic. So this is, you can qualify for the FMLA under those circumstances when ordinarily you would not be able to for that reason. So it's basically, and it's at least partially paid. It's basically a version of parental leave like we have never had in the United States before. And it's partially paid. The first 2 weeks, let's say you had the 12 weeks of FMLA available to you, the entire 12 weeks. The first 2 weeks of that is unpaid. You can take the emergency sick leave that I'm going to talk about in just a second. You can take that for the first 2 weeks, and then you go into this paid leave situation where it pays up to 2/3 of your salary, up to $200 a day. So that continues for the whole, the remaining 10-week allotment. So again, that partially paid FMLA is only available if you are taking it for the reason that I've described, where your child's school is closed or their daycare is closed due to COVID-19. And another kind of important caveat is this, what I'm talking about is an expanded reason to take the FMLA. It does not give you another allotment of FMLA. So you just get your basic 12 weeks. Now, so, keep that in mind. Say you had to take off last spring, you had surgery and you took off 3 weeks. Well, you're only going to be, have 9 weeks available. So I just stress that because that's been a source of some confusion or questions that we've received. Okay, so let me now move to emergency sick leave. This is a provision that the government passed where it gives you 2 weeks or 80 hours of paid sick leave. It doesn't come off of your time. Instead, this is leave that they have to give you if you need to take off for a COVID-related reason. Okay, and so this would be, for example, if you've been exposed to COVID-19 at work or in your off hours and you've been advised by your doctor to self-quarantine. It would be available if you have symptoms of COVID-19 and you're seeking a medical diagnosis. It would include time spent waiting to be tested and waiting for the results, or if you're in self-quarantine upon a doctor's advice. So if you have had exposure, you need to get your doctor to certify that the doctor has recommended that you take off from work because of the self-quarantine situation. So if the district makes telework available, well, then you're teleworking and you're not taking emergency sick leave. It would only be available to you in a telework situation is if you're ill with COVID-19 or a family member's ill and you need to take care of them. All right, and then the last thing I'm gonna kind of pivot from all of the COVID-19 related stuff and talk about the Whistleblowers Act. The Whistleblowers Act is a state law that's been on the books for quite a while, and it prohibits retaliation against a public employee who reports a violation of law to an appropriate law enforcement agency. And I want to highlight 3 elements that are very important if you are thinking about you're in a situation where you may need to avail yourself of these rights. Under the law, a violation of law is defined as a federal or state statute, an ordinance, or a rule that has been enacted, like by TEA, a commissioner's rule, pursuant to a state statute. So let me put it another way. A violation of law is not a violation of policy. A violation of policy does not if that's what you're reporting, that will not entitle you to whistleblower protection. It's not considered a protected activity. Also, the report needs to be made to an appropriate law enforcement authority that is not just reporting the violation of law up your chain of command in a school district. Instead, it's got to be an authority outside of the school district. So, and the law says that the entity has to be actually responsible for regulating or enforcing the law. So generally speaking, in a school district setting, that's going to be TEA, or if it's some kind of criminal activity, it could be the district attorney or the police or the sheriff. And the third thing I want to mention is this is an anti-retaliation provision to show that the report triggered the adverse employment action that you're experiencing. The district needs to know you made the report. Otherwise, you're not going to be able to connect your report and the adverse action taken against you. So those are three particular issues that come up a lot when people are trying to seek the protection of the Whistleblower Act. So I think that's all my time, and I will pass it along. Thank you very much.
Our next speaker is Patty Quincy.
No, our next speaker is Jamie Womack-Williams, actually.
Oh, sorry.
Okay, I had Patty down too. Okay.
Oh, I'm sorry.
I'm going to talk to you a little bit.
Well, actually,
that's okay.
I'm sorry. It was kind of a quick. Just wanted to remind everyone that after Jamie speaks about your additional rights, we are going to have some more discussion about your First Amendment rights and your protection as an employee, with a particular kind of focus on employees who are elected to serve in kind of elected positions within their union or within their campus. So stay tuned for that. That's coming up in part 2. Sorry about that, Jamie.
That's okay. I'm going to talk to you about several issues as far as your job is related. The first thing we're going to talk about is contract abandonment. We are past the penalty-free resignation date, and there are things that you must consider before you resign and potentially get a mandatory 1-year suspension on your certification through the State Board of Educators certification. So number one, if you are feeling the need that you need to resign, call your local union representative before you ever resign. There are things that can happen, such as a negotiation with your school board to accept your resignation. There are some good cause reasons to resign mid-year, and some of those do include like a serious illness or a health condition of the educator or a close family member. And what we would do is we would just provide documentation of that illness or that injury or the change in your family's needs before you ever resign. Remember that don't take your administrator's word for it that you can resign mid-year. Only the school board can release you from your contract. The next thing we're going to talk about is planning and prep. Each classroom teacher is entitled to at least 450 minutes within a 2-week period or 10 days. Planning and preparation period under the section of the law may not be less than 45 minutes within the instructional day. So basically what that means is that you can't be given 15 here, 15 here, and 15 here. It has to be one 45-minute block. During the planning and preparation period, a classroom teacher cannot be required to participate in any other activity. The Attorney General of Texas has ruled on this and says that the planning and preparation period is for planning and preparation, and it is unlawful to mandate teachers' attendance at group sessions, ARD IEP meetings, PLC, grade level meetings. If you attend any of those during your planning and prep time, you must go voluntarily to those meetings. If you receive more than 450 minutes in those 10 days, your administrator does have the right to take some of your planning and prep time. For instance, if you receive 50 minutes a day, that's 500 minutes over the 2-week period. So your administrator would be able to take one of your planning prep periods to mandate you to go to a PLC grade level meeting or an ART IEP meeting. So just look at the number of minutes that you're receiving and determine if they can lawfully take any of that time. We also, on our Texas AFT website, there are several links to case laws regarding planning and prep. The next item is your duty-free lunch. Each classroom teacher and full-time librarian is entitled to at least a 30-minute lunch period free from all of your duties and responsibilities connected to the instruction and supervision of students. If there is a personnel shortage, extreme economic conditions, or unforeseen circumstance, they can legally take one of your lunch breaks each week. Again, if that is happening to you, please contact your local union representative for more assistance with that. The next thing is about lost or stolen student-issued instructional textbooks or technology. The Board of Trustees of a school district cannot hold you legally liable to pay for instructional technology or textbooks that have been lost, stolen, misplaced, or damaged by a student. That includes textbooks, calculators, tablets, laptops, any of those things that your district is issuing to students. The only stipulation that they ask is that school employees act in good faith to maintain these items, such as if a student does report that something has been stolen, misplaced, or damaged, that you report that immediately to the district. The next item is documentation in your signature. You may be faced at some time with a written reprimand and that you don't agree with. Go ahead and sign it. If you fail to sign a written reprimand or a memo, it could potentially result in another reprimand for insubordination. Sign it and make sure that where you sign it next to your name, it states something like, my signature indicates that I have received a copy of this, but does not indicate that I agree with the content. Public information in your personal electronic devices. School employees must maintain text and emails received on their personal devices that include your cell phones, personal tablets, personal computers, that is related to district business. Public information held on your private devices or in a private account must be released within 10 days upon a request being made to you for that information. Employees have to maintain these documents received on their personal devices during their tenure and even after you leave that district. If you fail to provide the documents that are being requested, it could result in criminal charges against you. So just a little word of advice, don't use your personal cell phones, your personal email to communicate about district business. There are several things out there that you can access for free, like a Google Voice number that you can just download the app to your phone and it assigns you a phone number. You can text parents, students, and all of that can be tracked. It's easy to go online, print all of those text messages out. Another app is Remind 101 that a lot of educators use to communicate with students and parents. Easy to go online, print out any communication. If you feel like you need to file a grievance, number one, contact your local union immediately if you think you have a grievance. Typically, all grievances must be filed within 15 business days and all appeals must be filed within 10 business days. However, check your board policy because some districts have additional steps in their grievance policy, but contact your union rep and we will help you walk you through that process. But also to note that in 2015, some districts could potentially exempt themselves from specific state requirements if they became a district of innovation. So if you teach in a district that is considered a district of innovation, please check your district's policy to see which one of these things they may have exempt themselves from. And now I'm going to turn it back over to Zeph for questions and answers.
Thank you, Jamie. And I know that some of those rights that you've talked about were longstanding rights that happened before COVID, but there may be new utilizations for them. For example, the lost textbooks and electronic equipment. We know that we're going to have some students coming back to the room. We know that we're going to have some students that are staying online. And the practicality will likely be many of the students that are back in person Teachers may well be in a place where they need to make sure that they have devices, because they probably have to teach the kids in front of them the same way that they're teaching the kids online if their district has forced them to do both at one time. So will we be including any of these information in the documents for those that registered?
Yes, and also you can go to the Texas AFT website, texasaft.org/COVID, and you will find links to the PowerPoint presentation and all links to all of the issues I just talked about that explains them more in depth.
Great, thank you. So if we could bring up the full panel, we do have a few questions that have come through. And I want to start off with this first question, I think, to Martha. We have a question from Teresa in Conroe ISD. Do we actually have any specific rights with COVID? And I think that you talked about some of those, how they apply to COVID. But the second part of the question is also, do we have to abide by our contract as written?
Well, I mean, generally, yes, you need to abide by your contract as written. I'm not sure if this is a contract abandonment kind of question. In other words, are you able to resign from your contract now? That's an issue that Jamie talked about, where you need to try and work that out with the school district before you resign. And a number of times, the districts are going to have to be dealing with this a lot more than they ever have. It's just, unprecedented. And so, I don't know what the districts plan to do, if they are going to accept resignations for, if somebody's got a medical condition or concerns, if they're going to accept those resignations, or if they're going to try and hold the teachers to those contracts. But the starting point is to talk to your district and figure out where they're coming from, talk to the union, and to find out what your rights are. I hope that answered your question.
Thank you, Martha. The second question comes from Elizabeth at Northside ISD. Can we take personal days off from school without being reprimanded or pressured, especially during these difficult times?
Yes, you're entitled to take the personal time in general. There are some good commissioner decisions on that. I mean, the district does, have some authority. Like, for example, a district will typically prohibit teachers from taking time off around the testing, the testing, standardized testing. So they can have some rights to have some sort of, I don't know, I guess you'd call it reasonable control. But your personal time is your time. And so again, start with making the request and probably, I guess, before you do that, talk to the union to see if the union rep anticipates any problem. Then make the request, see what they say, and we'll take it from there. But I mean, generally speaking, your time to take off is your time.
Thank you. We have another question. This is from a paraprofessional. And Diane is asking, what about paraprofessionals? Will we have to cover classes for absent teachers when there are no subs available? Is that legal?
There is some, flexibility for the district in terms of that. They are not supposed to put certified people in the classroom without, for significant periods of time. If they do that, they have to send a notice to the parents that they are being, taught by somebody who is not certified. So I would say in that situation, I mean, they're really not supposed to do it. The students are entitled to have a certified teacher. Having said that, I think the reality is that many districts do it. I think, it kind of needs to be A case-by-case evaluation, if it's like for one day or one period, that's one thing. If it's something that's going to keep happening, or it's on a long-term basis, and by that I don't mean very long. I mean, more than just sort of an ad hoc basis, I would definitely contact the union, because the district's supposed to have a certified teacher in that classroom.
So we have a couple of really good questions up next. And I know that, Martha, we did the webinar on the ADA last month with some of the FMLA that you talked about today. And the question from our callers or from our viewers is, are they able to be utilized together? Can they utilize both of them, or is this they pick and choose?
The utilize together.
Can the FMLA and the ADA be combined, in other words?
Well, they really, they have different purposes. The ADA is supposed to keep you working. You're still working, but you have an accommodation for, like you're doing virtual teaching. You're still working, you're just not doing it from the classroom. The FMLA is the opposite. It's designed to give you time off when you're not able to do the work. Now, it is a common accommodation under the ADA, bear with me, for them to give you FMLA time off if all you were otherwise able to perform the job, and all that you need is a little bit of time off. Again, I mean, that's the normal situation. How that's going to play out in the COVID world, where there are a large number of people asking for accommodations and time off, and then that starts to touch on what would be considered a reasonable accommodation. Does it put an undue burden on the school district? But sometimes unpaid leave, I guess what I'm trying to communicate is, yes, sometimes unpaid leave, like you would get under the FMLA, could be considered a reasonable accommodation under the ADA.
Martha, for our practical purposes, we have several of our teachers who may be going under particular treatments. They may be asking for an ADA accommodation to be able to teach virtually, but they may need intermittent leave through FMLA to go to a chemo treatment every Friday at noon. I think that would be would that be like a practical example of where they should probably be applying for both?
Yes. Yes.
Okay. Okay. And our next question, and this is a good one, from Cedar Hill ISD, and I can absolutely understand why this question is being asked. Can I stage a district-wide sickout without legal consequences?
I think the answer to that is people have their leave available to use for lawful purposes. And if they feel like they cannot go to work given the circumstances that they're facing, then they're entitled to try and use that leave. So that's my answer to that question.
So we have a question from Gina and Gilmer ISD. Are teachers required to wear masks in the classroom? I'm pro-mask, but any whole group videos that my son's teacher sends me, I'm a teacher on FMLA, she's not wearing masks with the face-to-face kids. That's kind of scary.
Yeah, very. I would say that whether, that's an individual district enforcement decision, I would certainly take those concerns to the administration and relay them. I think that's obviously a valid and serious concern, and ask them what are they going to do to enforce any sort of mask requirement. But the mask is an individual school district decision.
Latanya from Duncanville ISD asked this following question. Are school districts required to provide PPE? Are school districts required to disclose if you've been exposed to COVID?
Yes, they're required to provide PPE. If they're not, then that's something that you need to let the union know about. Obviously, that's of grave concern. And the second question, tell me again.
Are they required to disclose if you've been exposed to COVID?
Yes.
So, and just as a matter of fact for our members, there is a list of, and we can find out for you if you need to talk to the union. The TEA did provide PPE to all school districts. They did use part of the $1.2 billion, about 200 million of it that they received from the federal government in March, to provide PPE for school districts. We know that's not going to be enough. We know that it's not going to last, but certainly you should be finding out how much they received and how much you should expect on campuses. Everybody should expect to have masks provided. Everybody should expect to have cleaning supplies provided. If they're not being provided to you, please let your union know as soon as possible. So we've got a question from Elizabeth Welch. Do we need to use Google Phone for union organizing? And I think this might have been in relation to the concern about school business being on your personal phone.
Patty or Jamie, y'all want to take that one?
Well, I'm going to step in, and the lawyers tell me if I'm off on this one. If your union business is your personal business, it is not school business and would not be considered in the type of business that must be maintained on your personal device that Jamie was talking about earlier. If you are doing union organizing with your organization and others, that is not subject, even though the topic may be people at your school, on your work site, it's your bus barn. So that is not applicable. You may choose to use a Google phone number for those purposes to be able to keep your separate organizing work from your actual personal, but that's going to be a choice for you. You won't be subject to the same requirements to maintain that data as you would if you were, say, having conversations with the parents of your students or others on your phone. We would definitely recommend that you use a Google line with perhaps a different type of system, or better yet, request from your district that they provide you the tools to be able to make the contact to your parents as they're requesting and needing. Okay, this is an important question for folks that have students coming back with COVID. It comes from Rochelle. Rochelle wants to know, what are my rights if students refuse to wear a mask in the classroom?
I think that that's an issue. Again, you need to talk to your district and find out what the district's rules are and report that student.
And we have another question from the paraprofessional group, Rosemary and Cyfair. Why are admins or professional employees getting paid to quarantine, yet the paraprofessionals are not?
Well, I don't know. I mean, I think that's a fair question. I guess, the district may be, and, I think the union could help you kind of figure out, do a Public Information Act request, contact the district to find out what the rules are. And if, we've got a situation where they're giving additional leave to admin people that's not available to the paraprofessionals, I think that that's an issue to take to the school board, because that's an issue of basic fairness. And we all know that the people who are actually in the classroom need that, they need the paid leave more than administrators do, who have less contact, at least in most situations, are having less contact with students and parents than the people who are on the front lines.
Martha, under the Families First Act, minimally everyone has been given an additional 10 days of leave for exactly this reason. This would absolutely apply to our paraprofessionals, correct?
Oh, yes. Yes. The emergency sick leave applies to all employees, regardless of your job title.
Okay, we have an additional question from Will and Colleen ISD. Who regulates and ensures schools are maintaining social distancing, wearing masks, and checking temperatures?
You know, under the governor's orders and the attorney general's opinions, they have put that, you know, a lot of the questions y'all are asking me, the politicians have put that in the hands of the local school officials as opposed to the health authorities. There's been a big clash, as you probably know, as to who's in charge. And unfortunately, in my opinion, the governor has preempted local health authorities and has put that in the hands of himself and the commissioner of education, and the result of that, and then they've kind of given it now to the school districts, and the whole thing has been geared to taking it away from the local health authorities who would otherwise control the situation.
Ladies and gentlemen, we've come to the end of our Q&A time for the part one of this series. I want to thank our panelists who've presented today and helped answer these questions, brought forth some of this great information. This is just the very beginning. This was our very general Know Your Rights section to kick this off. Part two, we're going to go deeper into your First Amendment rights, how you can interact in social media and stay on the right side of the law, what you're able to go over and share and on matters of public policy, and who really are those people that are in a special category able to make proper critiques and speak for others on matters of public policy. Stay tuned for part two as we talk about your First Amendment rights. And thank you for being part of our Know Your Rights and Responsibilities podcast as they're going to continue over these next several months. Welcome to part two. We will be speaking today with our Legislative Counsel, Patty Quincy. The topic today's Know Your Rights and Responsibilities session is, what are your First Amendment rights as a public school employee? And what rights do you have, and how can you speak out legally against policies that you don't believe are correct in your district? To take us through this discussion and talk to us about what is in the Constitution and how to move this forward, and who are those people out there that could and should and have a fundamental right to do this, I bring up Patty Quincy, Texas AFT Legislative Counsel. Patty?
Thank you, Zeph, and thank you all for taking the time to be here. I really appreciate your participation. As Zeph talked about before, one of the things that we see from the people in power is attempts to silence you. And we all know that as citizens, we have a First Amendment right to free speech, but as educators, you have a special duty. And one of the big reasons why those in power are attempting to dismantle our public education system and to hinder voting at every opportunity, including the latest attacks on the United States postal system, is that an educated electorate is a critical electorate, and that scares those in power. So it just goes to show how critically important your voice is and how important your job is as well. Now, speech involves a matter of public concern, according to the Supreme Court, when it's, quote, fairly considered as relating to any matter of political, social, or other concern to the community. Now, speaking in the context of the current pandemic, what is a more important public matter than the health and safety of children? The Supreme Court has held that the First Amendment does not protect expressions made pursuant to an employee's official duties, and we'll talk about that a little more. But what the Supreme Court does look at is it uses a balancing test, and it'll consider when the interest of the worker as a citizen commenting upon matters of public concern outweigh the interests of the state as an employer in promoting the efficiency of services it performs. So that's going to be the test that you'll see from case to case. But as I mentioned, there are some instances in which the case is determined that if an employee contains an element of personal interest, then it may not qualify as a matter of public concern. Yet other instances show that if it is incidental, that an employee might have some kind of personal interest, then yes, it is a matter of public concern. So again, that balancing test is really an important thing. But one example where it does not protect expressions made in an official person's official capacity is an example that I'll give you of an athletic director. There was an athletic director who gave a very impassioned speech about the school's mishandling of the athletic fund. The courts determined that that was not protected. So there are a few instances where you have to make sure that you are speaking as a matter of public concern for a greater amount of people. And one of the things that I want to emphasize is that your voice is so vital as educators. Our work is powerful is not just a slogan that we use. It's true more now than ever these days, when the work of educators and support staff like food servers are feeding children and entire communities. Our members in Texas have given away thousands and thousands of free school books to low-income kids who don't have the same access to books or online libraries as other kids do. Our members have also provided personal protective equipment where schools are running out or have not been provided with the material that TEA said it was going to provide. So the list goes on, just the amazing work that the union does and the amazing action that you as frontline workers are able to make in public. So just an example of some of the big appreciation that we've seen out of teachers or for teachers recently is an example from one of our Dallas leaders. This is Yolanda Fisher, who made the cover of Time magazine. We're also working really hard to bridge the alarming divide that we've seen that our members have witnessed firsthand as students kind of fall off the radar and are not able to fully participate in online learning with their classmates. So there are so many important issues and topics that specifically affect your kids. And that's the thing about teachers. You refer to them as your kids. And that's something that's really unique to you. And also, I wanted to emphasize that polling shows, and there's been polling after poll after poll, that educators are among the most trusted of public servants. And again, this is true now more than ever, when the public is getting just a little taste of what you do, and they're realizing that providing childcare and educating a child are two very, very different things. Teachers are not babysitters. And yes, what you do is brain science and human development and sociology and a whole lot of other things rolled into one. So as a practicing teacher, as a bus driver, as a custodian, you have the unique authority and expertise to speak on what will and won't work in the classroom environment, in the cafeteria, or on the school buses, as districts are discussing reopening plans. That's why it's so critically important to have a voice in your local district, because you are the expert, you know best, not the administrators who don't spend much time in the classroom, and certainly not the governor who doesn't seem to have the best interests of students and teachers at heart. When we have actual educators come testify before a legislative committee to say to them to their faces that their idea won't work, and this is exactly why, even ideas that have strong momentum can be stopped in their tracks. And there was a great example of this just this past session when we had 3 very brave teachers take a day off and drive down from Dallas, and they made a world of difference and changed the complete narrative around a pay-for-performance scheme that would have based teacher salaries on tests. Imagine where we'd be right now under those circumstances. So I just cannot emphasize how much the kind of moral authority and standing that you have. So it's incredibly important that you speak up at all times, but now more than ever. And one of the things that I've noticed in the past, working for the teachers union for the last 16 years and working for the legislative budget board before then, is that teachers are threatened in so many ways. Every session, they threaten your dues deduction, they'll threaten your salaries, they'll try to privatize your pensions. There's so many things that they try to do to you, but I've never seen the kind of anger and righteous indignation from teachers. And I think the difference is here is that they're not going after your pension. They're not going after your salary. They're going after your kids. And this is what's made it so very personal for so many of our members who I've just heard in tears when they come to realize that they have to make a balance between taking care of their kids at school and taking care of their kids at home. And that's just not a proper choice for any professional to make. So only you have the moral authority to make this kind of statement in this slide, where he says, quote, "Teachers are willing to take a bullet for their kids, but now what you're asking me to do is take that bullet home to my family." Now, this is a stark and shocking and blunt statement, but it's entirely accurate. If it came from anyone else, it might be considered hyperbolic, but when you, a classroom educator, say this, people know it's true and they listen. And when it comes from you, it means so much more. Another good example is this teacher who's also participating in Red for Ed, which is why several of us are wearing red today. And she asks a simple question. If TEA can track STAR tests and students for years and years within an inch of a student's life, then of course TEA can easily track COVID exposures and spreads. Yet the latest that we've heard from the Department of State Health Services and TEA is that they're still in discussions of whether or not to collect this incredibly important information that TEA needs in order to determine where to send its PPE and where to send additional resources needed. So I cannot emphasize just how important it is for you to speak up on social media. Some of these posts got thousands and thousands and thousands of posts. It gets parents engaged, it got students engaged, and really this, in a few words that could be easily tweeted, really succinctly encapsulated what this whole scenario is about. You're not only endangering teachers, you're not only endangering students, you're endangering entire communities. So it really kind of shows what a prescient issue this is and what importance it is to speak out. And speech on a matter of public concern is, as we spoke about earlier, we do want to make something very clear when you are speaking as a public employee, that you are speaking on a matter of concern. What you don't want to do is make personal complaints. Now, while your job performance may feel like a very important matter of concern to you, it does not constitute a matter of public concern. Neither does a matter related to your official duties. Remember, again, that athletic director example. Making personalized attacks on a specific individual makes it very, very difficult for you to be able to say that you're trying to comment on a matter of public concern and that you're merely concerned with what's going on in your schools. One of the things you also want to make very clear is that this is a matter affecting many people, especially children. And this is exactly what your expertise is. So again, when you have that kind of moral authority and moral standing to be able to say that that what's going on isn't right, people are going to sit up, people are going to listen. And when you speak on a matter of public concern, when it's, like I said, and it's a matter as important as the lives of children, then it's really hard to argue that you're being selfish, really, when you're talking about children and standing up for children and your coworkers. And another thing to remember is that many of our local school districts and campuses have site-based decision-making committees. They have a district advisory committee. They might have a variety of other kind of elected positions that teachers might have on a campus. So there is a little difference between speaking as an individual public employee on a matter of public concern and speaking as someone who's in an official capacity. And in fact, our own Martha Owen took a case all the way up to the Fifth Circuit that kind of shows that there is some additional kind of different protections when it comes to folks who are in a leadership position. Actually, let me go back a slide. Yeah, on speech of matter concern, the Supreme Court has held that the First Amendment does not protect expressions made pursuant to an employee's official duties. Again, so that is an important thing to remember. But another factor that's considered when the state looks at these cases is whether the speech is on a matter of public concern and whether the comments were made against the backdrop of widespread debate in the community, just like this time now. So now more than ever, you've got that ability to speak out on social media, to show what's going on your campus, especially if you're saying, as an educator, my concern is that my students will not be protected, that my campus will not be protected, or that my coworkers won't be protected. So there's a really kind of clear way of making this expression clearly to be a matter of public concern, and clearly to be an urgent matter that is worthy of other people speaking out. So getting back to the folks with kind of a elected position in several of these different categories, there is a little difference, because you're not speaking as an individual citizen, but you're acting as an elected representative of the faculty. And if you're simply communicating the views of the faculty to the administration in compliance with your duties as a committee member, then your speech is protected. Just because the administrator or school doesn't like the message that you're conveying, they cannot shoot the messenger. You are an elected employee, and it doesn't mean that they can retaliate against you for simply performing your duties as an elected employee. So this goes for those who are elected to site-based decision-making committees, district advisory committees, but it also affects those who represent your colleagues for the union. So we're talking about building representatives, building stewards, folks who represent their folks on the campus. So that kind of insulates you a little bit more in the sense that you are not just speaking as an individual, but you are speaking as an elected official who's been duly elected by your peers. So that's a really important thing to remember. And it really kind of gives our union members a little more protection, in the sense that that they're able to say uncomfortable things to the administration. And one of the things that I really hope to get through in the importance of why we join a union is that if you're a part of a union, you don't have to pick up a phone call to make an uncomfortable conversation or to start an uncomfortable conversation. What you do is you call your union. And that's something you heard Jamie say when she was talking about the other rights. If this is violated, if that is violated, call your union. That is something that I can't emphasize enough. It is so important to know that someone has your back, because you are so busy in the classroom. You're so busy reinventing how you educate children these days. There's a lot on your mind. There's a lot on your plate, but that's what we're here for. We're here to have your back if ever your rights are challenged or in any way denigrated. Then we're here to make sure that all of your rights are protected. Now, in Texas recently, you've probably heard, or you might have heard from our national union, there is some discussion about a resolution that AFT passed at our national convention. And what happened, the resolution essentially says that AFT would support strikes on a case-by-case basis where it's legal and only as a last resort. So a lot of media kind of conflated a lot of things and is, kind of saying that teachers are out ready to strike, but that's not quite the case. Some states actually allow for teacher strikes, but Texas is not one of them. Those states that don't allow teacher strikes or that are anti-collective bargaining states are called right-to-work states. But around the union, we call that right-to-work for less states, because that means employees typically have less protections, get less pay, have less benefits. So after all, the idea behind collective bargaining is just a simple concept that employees should have a say in their working conditions, which of course produce great learning conditions. So it is so important that although we can't strike in Texas, there are a lot of other things we can do. But I just want to make sure that you know exactly what's at stake with striking. The prohibition on striking is located in Government Code Section 617.003. And what it says is that a public employee may not strike or engage in, quote, an organized work stoppage against the state or political subdivision of the state, like a school district. What it also says is that all civil service rights, reemployment rights, and any other rights, benefits, and privileges earned from public employment could possibly be stripped. So this is a very draconian penalty, considering the fact that you have already earned your pension. So this is a really stark, very right-to-work state kind of legislation that really wants to silence educators at every turn. So technically, if you were to strike, being part of an organized work stoppage, it is possible that you could not only lose your pension, but you could also see sanctions applied to your certification. And again, if such a thing were to happen, or if you, before you even want to speak out on matters, join the union. Because again, if ever you encounter any kind of pushback from merely speaking on social media or having an Amazon wish list, if you can believe this, and this pandemic has really shined a light on mistreatment of teachers. Some teachers are being told they can't even put their Amazon wish list on their social media, which is absolutely absurd. But again, if that's a problem, pick up the phone, call the union. Now is the best time to join the union, especially now when we don't know what's going to happen in the coming year. There's so much uncertainty and so much lack of leadership among our state and local leaders. It's so important that we be the alternative to the lack of guidance. So in place of striking, there is so many alternatives. Joining the union is the first most important step you can make. As Zeph spoke about earlier, our power and ability to organize is the proof is in the pudding. We've seen in Socorro and El Paso, San Antonio, just where the best reopening plans are located, we're seeing that it was because our teachers, our members, our unions, and because we're locals all over the state, we've got community relationships. So because we have relationships, we see action. And relationships are everything. And again, the best part is having locals throughout the state. We have relationships on the ground with administrators, local health authorities, other community members and leaders to ensure that we aren't the lonely voice calling for the best interest of children and all school employees. And we're also very well known to seek redress through legal action. And Martha Owen represents us really, really well in that. So you'll often see us in the news doing that kind of an action. So there are a lot of alternatives that we can take. There's also actions, digital actions, such as letter campaigns and letter writing to the governor, to Mike Morath, and we've seen results from that too. Letter campaigns to school districts. Just engaging in a little bit of organized activity really shapes and really kind of changes the narrative of how a school is rolling out its reopening plan. And again, because we've got locals all over the state, we have relationships with local elected officials. And knowing those local officials helps us to be able to engage in a safe reopening plan in conjunction with both the school district and the local health authorities. So I can't emphasize enough what importance it is to join the union now. And just because we can't strike in Texas doesn't mean we don't have a very powerful, very active union that is making change every single day. So thank you very much for your time and attention, and I'll be glad to answer any questions. Oh, and also I wanted to mention that you'll see some materials available linked on our in the chat. And also I would encourage folks to visit our COVID page and our Know Your Rights section of our COVID page. So there's lots of great information on texasaft.org. And I would also encourage you to sign up for our email list. And if you do that, you'll get notice of our action campaigns and letter campaigns. And you'll also receive our weekly hotline, which is a really wonderful kind of quick synopsis of what's going on from local to federal level education policy and politics. So thank you very much.
Thank you, Patty. I appreciate the presentation. A lot of great information there, and it's led to several great questions. And I'd like to start off with this first question from Bobby in Austin. Bobby's question is, what if you're not elected to a position within your union, but you're leading organizing efforts at your school? Does the same additional protections for protected speech, do they apply to people who may be the chair of a committee, or they may be a building representative appointed by the local union?
Yes, they would be protected. That was another example, is that, and correct me if I'm wrong, Martha, but yeah, because you are representing a group of people, and it sounds as though it's kind of a formal, there was a committee, so that kind of sounds formal. So if you are indeed a spokesperson for a committee of some sort, then you are merely the messenger transmitting the message.
Yeah, can I add something on that? Just echoing what Patty said, Patty talked about, the First Amendment, which is the right of free speech, but also embedded in the First Amendment is the right of association. Mm-hmm. And so you have, if you are a member of the union and you are participating in a union action, union-related speech, then that's going to give you an additional measure of protection that can be important in an employment setting.
I mean, that's great words, because in my experience, I've seen all of these examples where people, they give some information, but they don't want to have their name used. And a lot of times you can try to work through problems anonymously, but that's not necessarily going to guarantee that people don't know where things are happening. But when you actually come out, when you file the grievance, when you speak on behalf of the union, when you make the public declaration, would you or would you not say that there's actually more protection for people then when it comes to issues of retaliation, because you actually have something to base a case for retaliation on? What are your thoughts on those, attorneys?
Yes, I mean, absolutely. Because it kind of goes back to what I was saying with the Whistleblower Act. I mean, you've got to be able to make the causal connection between your protected activity and whatever bad thing has happened to you that you're saying you were retaliated against for. So in any kind of retaliation case, you have to show the concerted activity. And so if you're just like Zeph said, if you are kind of doing things on the side, maybe your administrator knows about that or suspects you're involved. But if you are not, if you don't come forward and actually speak out and identify yourself, it's going to be harder for you to show that causal connection. So I would say, just like Patty said, two important things that you can say to kind of enhance your First Amendment protections is make clear, and it doesn't hurt to say it like this: I'm speaking as a citizen. I'm a member of this community, and I'm concerned about what's going on in our schools. That gives you protection, and it's double protection if you say I am a citizen and I'm a member of Texas AFT, and as a union member, I want to speak out. So, identify yourself. You are both of the things of being a citizen and being a member of the union add to the protection that you would have, as opposed to just sort of a regular employee speaking out just on behalf of yourself.
So Martha, would you recommend, for example, members that are speaking up at school board meetings during a posted public session, would you recommend that be the way that they start their speeches out? I'm a citizen, or I'm a citizen and I'm a member of whatever the local union is.
Yes, I do.
Great. So we have a question that actually falls along these same lines, Martha. Or Patty as well. This comes from Casey. Can we personally criticize the governor?
Patty, I'll let you take that.
Technically, yes. but yeah, you never know who's following your Twitter and doing word searches for his name. But yeah, I mean, again, you are a public employee. You are an expert. You are the top expert. the governor isn't. So it is, I think, fair. What do you say, Martha?
Yeah, I think so, but I think you have to be clear that you are speaking as a citizen. You are not speaking in your capacity as an employee. You are speaking in your capacity as a citizen. And I think it's important to identify that, and so that, again, you give yourself the most protection. So, just be mindful of that when you're making comments along those lines, and also be sure that you follow your district's social media policies.
Mm-hmm.
Don't use your email from your school, right? That all goes along with, this is something that you're doing on your own or in concert with your union, not as Mary Jones, elementary school teacher in this district.
Mm-hmm. Yeah, and I would also suggest no personal attacks. There's plenty of other reasons to attack the governor besides making it personal.
Yeah,
so be nice.
There's enough there. Policies.
As Michelle Obama said, we go high. So everybody go high on those pieces. We've got plenty of policy issues to keep focused on. You're exactly right. Patty, this next question is for you, and it comes from Kevin in Dallas. Can charter school teachers speak out about reopening without repercussions? And if their employer retaliated, would they have a case against their employer to protect their job?
It depends. As Martha discussed, he could possibly have whistleblower protection, which now applies just as of last session, thanks in large part to Texas A&T's advocacy, now applies to charter school employees. And we're actually helping a charter school employee right now who saw so many horrific kind of special ed breaking or violations of law. But yeah, it would have to be, again, if it's a violation of law, that would go the whistleblower route. But he certainly has his First Amendment rights as a charter school employee as well. Charter schools are technically public schools. We don't call them real public schools because they don't have elected governance, but we certainly have seen our fair share of charter school employees being retaliated against. Many charter schools don't realize that charter school employees are members of our union. So it's been kind of a surprise to some folks to get pushback. But again, I would urge everyone to join the union, because that is the way to ensure that someone's got your back no matter what. But yeah, in terms of you as a public employee, speaking out on your concerns, on a matter of public concern, on a matter of which you are an expert, then I think you are protected.
Thank you. And we've got a question from Nancy in Fort Bend that really has to do with protection of her privacy rights in this whole First Amendment conversation. How can you protect your personal info, pictures, and video when it's being posted to a website or social media by district personnel? For example, you are required to attend a professional development session by the school district. They're taking pictures and they're choosing to put it onto their public websites without necessarily asking you if you want to have your picture there. Is there any recourse for these employees?
Well, I'll take a shot at that. I think that there may be something that is buried in something that you've signed or they've given you that says that you have, by working in the district, somehow you have consented to this. But I think that that's a situation where definitely the right starting point is to let them know that you do not give them your permission, and you would rather not have that depiction of you or your information relayed to them or relayed to the public by them. So I would start by sort of declaring this is not something that you have consented to or that you want to consent to, and then let's see how they respond.
Martha, as a follow-up on that question, generally, especially when an employee first starts working for a district, they'll often ask them if they want to have their personal information restricted, their address, their phone number, et cetera, from public documents. Is there anything, I mean, are they unilaterally allowed to like write or include in that statement? I also do not want my image being used without my express consent.
Sure. Sure, that would be a good way to handle it. And, you know, the reason that they ask you about your name as and address is that's a, you know, information that that public employees can opt out of providing, you know, so your that info wouldn't be in the directory, for example. It's called directory information. So that's a particular provision that's in the Public Information Act. But yeah, that would be a good vehicle when you have to sign that form to kind of expand it, and that's a good idea.
Thank you. And this, Patty, this is a question that goes back to you. It comes from Rosanette. Can I use my ISD email to speak about action or concerns to address with my colleagues?
It's better not to. We recommend using, like Jamie was talking about, getting a Google email address and using some kind of third party vehicle, because you don't want to be said to be using district resources on district time. So if you're going to send emails, don't do it during your work hours. Don't do it on campus or using even the district servers. So yeah, I would encourage you to get kind of just a regular Gmail, which are free. Use those addresses instead.
Yeah, Patty, this is one of the recommendations we have as well too, particularly for union organizing reasons. We may or may not necessarily have the personal addresses of each of the employees, but the volunteer organizer or the member may be sending an email to those ISD addresses from their personal email on their own time from their own device. That's what we're saying. That's the difference though, right? They can still send to as long as it's on your own time, on your own device.
That's correct.
Yes, because your ISD email, this is another point as well too, and please attorneys check me if I'm wrong. Your ISD email is a matter of public record. Everything that you send on that email is a matter of public record. I could put in a request tomorrow for every email that you've sent during the month of August using your email address, and it will get sent to me. It may have some redactions of certain names or certain activities, but we could easily get a record of every email that goes through there. So you always want to be very cognizant of what you're putting in writing, particularly on any school district related device. Okay, we have another question here. You know, and this is a good question for people. When we're talking about matters of public policy, Martha, does it matter if you live in the district that you are discussing? You may work in one district and live in another. Are you able to speak in that district where you work as a matter of public policy, even though you live in, say, a neighboring district?
Sure. Yes, I think you can say, you know, I'm speaking as a citizen of Texas. I'm speaking as a member of the educational community. So yeah, you know, I mean, if you are, if you did live in the district and, you know, you pay taxes, blah, 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 you know, that's a good thing to mention, but it doesn't mean that if you live in a neighboring district that you cannot speak out. Again, just you know, identify why you're speaking. The court cases even talk about this. Which hat are you wearing? Are you wearing your employee hat or your citizen hat? And so you need to just sort of, you know, do everything you can to make sure that you've got your citizen hat on.
So we are coming close to the end of the time for our Q&A, but we've got one question left, and this one always does seem to to result in a lot of confusion. It's from Maria and PSJA Consolidated. Do the teachers or employees still have the right to record a meeting if they're the only one that knows the meeting is being recorded for documentation purposes? They've been told that they're not, that's not legal. And, where I think a lot of times the confusion comes in here is I do believe the law says as long as one party that is part of the conversation is aware it's being recorded, that's all is needed to make it admissible. But individual school districts may pass policies that say you can't record during a meeting without notifying all parties. So how does that work, Martha? What is the explanation there?
Okay, so I think you've kind of laid it out. Let me add a little bit more detail. So what the law on it's not against the criminal law for a party to a conversation to record that conversation secretly. Okay, that's not a violation of the criminal law. It would be illegal. Let's contrast that with kind of a wiretapping situation where you were recording the conversation of two people conversing with each other, and you were somehow or other you were tapping their phone line. That would be illegal. That's why you need a search warrant. Okay, that's what the criminal law says. However, like Zeph said, employers, and it's not uncommon these days in school districts. Not every school district has a policy like this, but we see them more and more. The school district, as a matter of policy, employment policy, tells its employees they do not have the right to record surreptitiously a conversation that they have, as an employee. And there's nothing that makes it illegal for a school district to have a policy like that. In other words, they can do that. They can restrict it. And so if this is something that you feel like you have the need to do, then you need to check your local policy, because the last thing you want to do is to violate that policy. There are other ways to kind of document what occurs in a conversation that you have with your principal, such as taking notes during that conversation and then writing the principal or the administrator, directly after the conversation and say, I just got through, talking to you about this, and this is what was said. And so you can kind of create documentation. So check your local policies as to whether or not that's restricted as an employment policy that the district has issued.
Thank you, Martha, and thank you for bringing this Q&A session to the end. What I'd like to do is just wrap up for everybody that's out there listening. The thing that you heard most often today is you actually do have rights. You have the right to speak up on matters of public policy, but how you do that may determine what the consequences of that speech could be. First and foremost, if you're going to speak on these matters, make sure that you're speaking for yourself on your own time, on your own device. Second, the more complex the issue, potentially the more serious the issue, call your union first. Let's sit down and develop a plan, because the individuals you see out there that speak out, that sign on to lawsuits, that put their name on to policies, that speak at the board, they've oftentimes sat down with us so that we make sure they understand what their rights and responsibilities are. We've developed a plan to help them protect themselves as much as possible, to make sure that they're doing it right. Just remember what we were taught in history classes. Rosa Parks took action that will never be forgotten in this country, but she didn't do it alone, and she didn't just decide to sit on a bus one day. She had a lot of really smart, brave people working with her to help develop the right plan, to make sure the right people were in place, to make sure that the consequences were mitigated, that the communication was where it needed to be. That's how we win. That's how we build power. That's how we make the change that we want to see in our public institutions for our kids, for ourselves, and for our families. So I'll just need to take one more minute of our time to go over our homework. We do have some slides coming forward. We want to remind you that the American Federation of Teachers has put out a science-based reopening plan that was developed with both educators and medical experts. It has a lot of the basics that we've been following as we've been advocating for what our environment should look like before we return to in-person schooling. That is online. If you registered for this event, you will get a copy of the links to those documents later. There's some homework for you. We want you to speak out. Speak with a Texas AFT rep in your area about organizing in your district. Send out letters. Tell Governor Abbott to do his job. This is the best way for you to be able to speak to the governor, because we've outlined for you exactly the things that he should be doing, exactly the things that he should be paying attention to as the highest elected official in this state. Tell your U.S. senators to pass the HEROES Act. That's where we get the additional funding to make sure that the PPE doesn't run out on our campuses. Red Wednesday campaign. I hope you noticed that all of our presenters today were wearing red on this Wednesday to remind everybody of why it's important to keep our staff and our students safe. Texas AFT has our election endorsements for 2020 up. The only way that we change the way that our schools and our state is running is we get out and vote and change the people that are in those seats. What is the definition of insanity? Continuing to do the same thing, continuing to elect the same people. It's time that we have people that share our values in office. Make sure that they are speaking about what is important to us. Our union, regardless of what they say, does not have parties. We have issues. And we need to make sure that those individuals we are voting for align with the issues that are important to us. Finally, join AFT. Join Texas AFT. Sign up online, texasaft.org. Talk to your neighbors. Talk to your colleagues on campus. Follow us on social media to keep up with the latest breaking information on education. Find us at Facebook at Texas AFT, on Twitter, and on the website. I want to thank you for spending your last 45 minutes with us as we completed part 2 of our web series, Knowing Your Rights and Responsibilities. Stay tuned for further details as we continue our web series and podcast on these many important topics that relate to your job and your work. From Austin, Texas, signing off for Texas AFT.